In this lecture, we will focus on copyright and the Constitution, and specifically on Section 16, or freedom of expression. So in this lecture, we will discuss the impact of the Constitution on copyright, specifically on the right to freedom of expression as per Section 16 of the Bill of Rights. When we think of copyright, and as we said in the previous lectures, copyright is, of course, a bundle of rights that attach to the copyright owner and that restricts other people from doing certain things that will infringe on this copyright bundle of the copyright owner. So, in a way, copyright prevents other people from copying the creative endeavors of the author or of the copyright owner. On the other hand, we have Section 16 in the Constitution. And Section 16 clearly delimits the freedom of expression. So where copyright puts boundaries up, Section 16 tries to get rid of those boundaries by including in this freedom of expression the freedom of the press and other media, the freedom to receive or impart information or ideas, the freedom of artistic creativity, as well as the academic freedom and scientific research. So clearly there can exist a tension between copyright and the boundaries that copyright sets, and then Section 16 of the Constitution, which tries to open a flow of information and a flow of knowledge. Now we know that intellectual property is mainly governed, or copyright in our instance is governed by the Copyright Act and the accompanying regulations. But how should we then interpret the Copyright Act to, instead of creating a tension with Section 16, to rather in a way work with Section 16 of the Constitution and to not only protect but to also delimit this free flow of knowledge and ideas? Well, we know that Section 2 of the Constitution tells us that the Constitution is the supreme law and that all law or conduct inconsistent with the Constitution will be deemed invalid. And then furthermore, Section 39 of the Constitution tells us that when interpreting legislation and when developing the common law or customary law, every court, tribunal, or forum must promote the spirit, purport, and object of the Bill of Rights. So what does that mean? It means that we have one single system of law, and that single system of law is the supreme law. It is the Constitution. And all sources of law, including the Copyright Act, needs to be in line with the Constitution. And when will sources of law be in line with the Constitution? When it, of course, promotes the spirit, purport, and object of the Bill of Rights. So it clearly tells us that the Copyright Act must promote the spirit, purport, object of Section 16 of the Constitution. We see that internationally there seems to be a right to intellectual property. But as is the situation in South Africa in terms of property, we don't have a right to property or a right to intellectual property. What we do have is the right not to be arbitrarily deprived of our property as per Section 25. So, on the one hand, having an obligation, a constitutional obligation, will put an obligation on the state to facilitate the creation of intellectual property in the future. So if there was to be a right to intellectual property, that would mean that the state then had an obligation to facilitate the creation of intellectual property in the future. And in other words, to promote intellectual property. But when there exists such a right within a constitution, it may lead to an overemphasis on private ownership. And this is what we've seen with property in the past. Ownership and the ownership of property was regarded as this absolute right, this right that could not in any circumstances be infringed by no one, not even the state. And this, of course, in terms of intellectual property, will lead to monopolies and private monopolies taking over and monopolizing information and ideas. So perhaps a specific right in a constitution to intellectual property will, instead of opening it up and ensuring or facilitating future creation and future promotion, will instead have the effect of overemphasizing and of closing off intellectual property, the flow of ideas and of knowledge. We also know that Section 25 in our Constitution puts a huge emphasis on the public purpose and the public interest, on the redress of the injustices of the past, on reform and redistribution. So, if we apply that to intellectual property, that is then perhaps a good compromise. Because if the focus is on reform and redistribution, it means that also in terms of intellectual property right, the constitutional interpretation will rather broaden than close off. The constitutional interpretation will rather open up in the interest of a group instead of a single company or a single juristic person or a single private person. And we also see that copyright is then still subject to the Bill of Rights. And copyright, in other words, must be interpreted to promote the spirit, purport, and object of the Bill of Rights. Let's just for a moment remind ourselves that Section 25(4)(b) of the Constitution tells us that property is not limited to land. So although this is a very wide and a very non-descriptive description of what property entails, it is wide enough to include also intellectual property. So, as we've said in the past, what is the purpose of copyright? To, in a way, protect the expression of ideas. But the purpose of copyright is to protect ideas, but not to constrain the freedom of speech. So copyright is there to prevent copying, not to constrain the flow of ideas and of knowledge. We have in the previous lecture looked at fair dealings as a statutory defense to a possible criminal infringement of copyright. And we've said that fair dealings allows for certain exceptions wherein the use, the reproduction, or the adaptation of a copyrighted work will not constitute a criminal infringement. And remember that in terms of fair dealings, there are 3 situations or uses of copyrighted works that will not be a criminal infringement of copyright, and in other words, will be a fair dealings or will constitute a fair dealings defense or exemption or exception. So these 3 exceptions or exemptions include when works are used for the purpose of research or private study, or when works are used for writing a review or criticism of the work, and then also when works are used for the purpose of reporting current events in a newspaper, magazine, or similar periodical, or by means of broadcasting. So if a copyrighted work is used for research or private study, for criticizing or reviewing that work, or to report on current events, it will constitute the defense of fair dealings and will not be a criminal infringement of copyright. But we see that in terms of fair dealings, often the percentage considered as fair is around 10%. So what constitutes fair is also a difficult question, and this will be decided by a court on a case-to-case basis, focusing on the specific circumstances of that case. So there seems to always be a balance that needs to be reached, a balance or a weighing of the copyright of the owners versus then the interest of getting information, of reporting on current events, of research or studying. And we are going to look at two cases wherein this tension between Section 16, the freedom of expression, and then Section 12 of the Copyright Act that deals specifically with fair dealings will be illustrated. Now remember, we've already said Section 12 in terms of fair dealings, 3 situations when an infringement will have a exemption or a specific defense by means of fair dealings. So in the National Soccer versus Gidani case, the National Soccer Association releases weekly, monthly, and annual soccer fixtures or lists. And Sports Stake, it's a sports betting company, use these soccer fixtures or lists in their betting endeavors. So the respondent, the National Soccer Association, said that Sports Stakes, these tables, these weekly soccer fixtures or lists, constitutes a literary work. They are compilations and they are tables, and therefore they are literary works that constitutes protectable works worthy of copyright protection. And that you, Sports Stakes, do not have a license to use these literary works. These literary works are also now being unlawfully reproduced and published in all sorts of petrol outlets and shop outlets. And then Sports Stakes or Gidani in return argued that these publishing or reproduction of the weekly soccer fixtures were merely ways to inform the public of current events. And that therefore Section 16 of the Constitution, the freedom of expression, should apply, because the freedom of expression includes the freedom of the media, the freedom, of course, to receive or impart information of ideas. Furthermore, that there was no abuse and that there was no harm caused, as these fixtures or lists were not really valuable. The court then decided that clearly the National Soccer Association was to a great extent correct, because Gidani, or the Sports Stake betting company, was definitely using these weekly soccer fixtures, these lists, for their own financial gain. They were not using it to impart information or as a vehicle of press or the free media. No, they were using it to make money for themselves. And the court consequently decided that they had to deliver up, that they had to give back all these soccer fixtures and lists that they still had in their possession. What is interesting about this case is how the defendant tried to use Section 16, the freedom of expression, to justify their use of the literary work by saying, but we are like the press, we are like the media, and furthermore, we are merely imparting information to the public, and therefore we should have the freedom of expression. In the MoneyWeb versus Media24 case, 7 news articles that were published by MoneyWeb was then used and published again by Media24. So these were articles about current financial going-ons in the country. So MoneyWeb wrote an article reporting on these financial currencies and shares and the financial situation in South Africa. And then Media24 published some of these articles. They used some of the information, wrote their own little adaptations, but they also provided the link to the original MoneyWeb article. So the question before the court was, firstly, whether these articles, these news articles about the financial situation and interesting financial happenings in South Africa, whether that constituted a literary work. Because was it original enough to be protected by copyright? Secondly, if that was the case, whether Media24 copied or reproduced a substantial part thereof. And then whether this infringement in terms of fair dealing, Section 12 of the Copyright Act and Section 16 of the Constitution, perhaps constituted a fair use of this information or these articles. The defendant argued that the media is one of the main vehicles that ensures freedom of speech, and that it is one of the first or essential tasks of the media to disseminate information to the public. So in other words, to inform the public so that the public can become informed citizens who make democratic and informed decisions in a constitutional country. And then they also argued that fair dealings, remember those exemptions in terms of the infringement of copyright, should be also read through the Section 16 freedom of expression prism of the Constitution. So we should read the copyright and the fair dealings through the constitutional prism. So in other words, we must interpret Section 12 through the glasses of Section 16 in order to promote the spirit, purport, and object of the Bill of Rights. And that there will always be this weighing up of private ownership versus the freedom of expression. And the court then concluded that MoneyWeb failed to show that these articles are original or original enough to ensure that copyright subsists, and that the parts that were reproduced by Media24 were indeed original, and that there was really no infringement of copyright because these articles as published by MoneyWeb were not original enough to be considered worthy of copyright in any case. So there couldn't be any infringement of the copyright. And that the media indeed has the obligation or the duty to inform the public or to disseminate information to the public. The problem with this case is, though, that the court has left a number of questions unanswered. And the first one pertains to the question of whether news articles, so reporting on current financial news, will then never constitute an original work, so never be worthy of copyright. And therefore, the question remains, do news articles, so in other words, reporting on current affairs, be worthy of copyright? Will it be original enough to constitute copyright? But these two cases show us, in a way, how to work with Section 12, fair dealings, as well as Section 16, freedom of expression in the Constitution. How to work with these two articles, not opposing each other, but rather working together. So copyright, not focusing on stopping or limiting freedom of expression, but rather protecting instead of limiting. Because, as we said in the beginning, Section 12 and the entire Copyright Act still needs to be interpreted and used consistent with the Constitution. In other words, it must promote the spirit, purport, and object of the Bill of Rights.